All right. It is February 21st. This is Family Law, and today we're talking about child custody. But first, we're going to go back in time a little bit to the last chapter, which was about what? What was last chapter about? What was last class about?
Spousal support,
Spousal support was a big one, and
property division.
property division. Sometimes we just call it equitable distribution. Why do we call it equitable distribution?
Because it's hard to get it exactly equal.
Okay, because of why? Why is it hard to get it exactly equal? I mean, you add it all up and you divide it in two, right? We got good calculators.
Some of the debts cannot be attributed to both parties. They have to be one or the other.
Separate.
Okay. So there's some things, some types of assets, that's what our biggest weakness is. Some assets are not equally split. You can't just take the dot, you can't just cut them in the middle, right? Real estate, what's the rule of real estate? No two pieces are exactly the same, right? So no real property is what it is. It can be different. You can sell it and turn it into cash, but you can't split it and say you get half and I get half, or if I have a piece of property over here, you give me this one, are they going to be exactly equal value? No. How do you split up pension funds? How do you do things like that, right? All of those are hard to equally divide. We get pretty close, right? But equitable means that, well, it's more or less equal, right? One way of thinking of equitable. Equitable has a legal term. It means fair. Equitable, equity. You ever remember talking about the courts of equity and equitable powers of a court? What does that mean? It's based on some kind of concept of fundamental fairness, something along those lines. But we cannot just equally divide our assets, so we have equitable distribution. It just makes sense in how we try to calculate people's assets and split them up. We also can decide that it's not that easy just to come up with cash and things like that. So let me first, the assignment that we had for today, I'll go ahead and go into it. The assignment we had for today was about spousal support and property distribution, right? So let me pull up. The first question basically was spousal support, and I said go to Ohio Law and find out how do we determine spousal support. And then I gave you a little bit of a scenario, right? What's the basic scenario of the people?
Basically, they both want to go to school, but they decide that one goes at a time. So George volunteers to let Susan go first, and basically he works while she does that to support themselves, and he gets injured, and after they get divorced, he wants to basically claim some kind of right to the degree that she got.
Okay, so basically they're unhappy in their current profession. Okay, we'll call it profession, and they want to go off and be retrained, and they both have they look at different programs and they determine that, well, only one of us can go at a time. Why is that? They don't have the money to be both out of jobs at the same time, right? That's the concept. So one of them pays the bills. We can assume more or less they're debt free when she gets done with hers, right? That's probably unrealistic, but let's assume she goes rent free or debt free. This is a more simplified version than like a lot of times what you'll see, the cases that get fought out a lot of times have to do with people who've gone to professional school, like they're either doctors or lawyers or somebody, PhD engineering or something, where they're going to go to those higher levels of big income potential. A lot of times there's a second party who there's some good cases actually where you'll see one party, while they were first married, one of them was maybe an accountant, had a successful practice, or one of them was a lawyer and had a successful practice, and the other one's going to go to med school or to law school, and they're going to earn, and basically there's no no debt out of the whole thing, right? Okay, so you'll see those big dollars amounts and all that stuff, but what you have here is George and Susan both they want to go on and be retrained and have a different career path. That makes sense, right? It's a common scenario, isn't it? People are married, they decide one will invest in you to go to school first, and then you go and everything will be good. And we always assume that we'll just continue on in perpetuity, happy and right, move on. So luckily they don't have any parents, but they don't really have any property to divide. So my first question here is, and I gave you some facts. I said she earns $30,000 a year. They don't have debts. They have fairly standard bills, okay? But the primary question is, what would a court do in this circumstance? So what do you think a court would do? What is your first thought? So you read this thing, what do you think the court would do?
I think that they would order some kind of temporary alimony to where maybe, because it stated that he has 5 years basically before, at least 5 years before he will be able to work fully or go to school. So I think that they might have temporary alimony so that she can support him throughout the 5 years.
Okay. So let me first talk about temporary alimony. In a legal sense, temporary alimony is like a temporary restraining order style. Okay. That's the type of thing it is. It's temporary relief or a preliminary injunction. It's temporary while the case is proceeding. So I'm throwing that out only to say the terminology can be important. Temporary alimony in a family court case is if I file for divorce and pending the resolution of the property distribution and the final determination, we'll have a temporary order of support. Okay. Why might we do that temporarily? In this case, you can see, so you've raised a good point. They might give they probably would give temporary relief here. She's working, he invested it makes sense. He's now unable to work because he's injured, right? So the court would probably do that pending resolution of the ultimate decision. Okay, I only throw that out not to pick on you, but to say that terminology is important in how we think of it, because we would think a temporary support is something that would happen in the interim until it's finally decided. Because you also know that there are a lot of divorce cases filed. It can take a long time to get a final decision, probably, right? So that's what the temporary piece is. What you did say was what strangely we would call in West Virginia permanent alimony, potentially. In West Virginia, we call it permanent alimony, and that usually will sunset within about 4 or 5 years, no longer than 10, right? Realizing in the past, permanent alimony meant from now until you die or get remarried, but we still might call that permanent alimony. So your first thought is, he's going to be injured, can't work for 5 years. The court will probably order some level of spousal support for a period of time, right? Somewhere around 5 years. That everybody more or less agree to that?
He's not completely destitute, because if he's gotten hurt at work, he has compensation. He has income.
Okay, so because he was injured at work, he would have workers' compensation. Okay, here's my first objection to your answer, is you've assumed the fact's not in evidence.
No, it says that. It says that he was hurt at work.
It does say that, but you've assumed he would get workers' compensation because you know that's usually how that works. What if he intentionally got himself hurt because he did something he shouldn't have done? Would he necessarily get workers' comp?
There's not enough information.
Don't assume those facts.
Right.
I agree with you. He probably would have some form of income, especially if he got hurt enough to be 5 years out and we knew that. Well, that's kind of an overstatement, but okay. So I'll let you continue. Let's assume he has some other source of income in the meantime.
He's going to have to. He's got to pay rent. You know, he can't live without income.
Right.
Until they have that settled. And he would be entitled to reimbursement spousal support for working while she went to school to support them.
Okay. So we have, first of all, you have that there's some level of support will probably be here. And why would he get it? Why would he get support? And you called it reimbursement support, right? You know, that was what type would it be was my question. What type of spousal support might he get? It would be reimbursement. Why do we, what about reimbursement? That sounds, you get your money back, right?
Rehabilitative.
Okay, rehabilitative might be a separate thing, right? So reimbursement, why would he get reimbursement potentially? He invested in her 2 years of education, right? So he would get reimbursed for his investment. Okay, so that's a big one. Rehabilitative would be what? What would you consider rehabilitative? They could also get that. The court might also award him some level of rehabilitative. Let's say, so we're going to get to breaking this down here in a minute. The differences, because I think you can have more than one. For about how long do you think he might get rehabilitative spouse support?
Years it takes him to get back on his feet.
Okay.
For the 5 years at least. But
Well, I don't know. Let's go back up and scroll back up to facts we know. We know he's going to be out of work for 5 years because of his injury, but does she owe him for his injury? What does she have to do with that?
yeah, that's true.
We don't know. There's no facts and evidence that indicate that at all. Okay, Tori's thrown out that workers' compensation, we can't really assume it because it could take years to get it. She's also said he paid her way through school for reimbursement support. So how long did he pay for her to go to school?
2 years.
2 years.
Mhm.
Okay, and how long will it take him to do the degree he wants? 2 years. So reimbursement support relates to hers. Rehabilitative would relate to his, right? Do we know anything in the facts about whether or not he might be able to go ahead and go to welding school? Doesn't say. Maybe he could. Would there might be an offset of workers' compensation if he's able to do that? I don't know. We'll go into those details, but potentially, right? So right now we're looking at, well, he would get reimbursement support and rehabilitative support. Might he get the overarching permanent support just because they were married? Okay, that doesn't mean that's the benefits of the marital estate is what permanent alimony might look like. Okay, do you think they would get that?
Well, they haven't been married that long, have they? Doesn't the court take that into consideration?
Absolutely. We don't really know right now, but we can assume that I think you could have some level of assumption that they may not have been married particularly long time. We could assume it. Because it's not a fact that comes up, we can pretty much assume it's been short.
Right.
Right? The longer a marriage exists, the more chance it is to be a fact in how long you would get it and in how much. Okay, so how do you know? So I've thrown out those things. Those were general concepts about what is spousal support, but what is the law on it? Where would we find the law? I tell you to go look at Ohio law on this issue. Okay, where would you go?
Found the general, the factors that they take into consideration under ORC 35105.18, and that gives you all the factors.
Say your numbers again.
Sorry, ORC, the Ohio.
Revised code, ORC, the revised code, yeah.
35105.
3105.
Yes.
3105. So you go to the Ohio Revised Code, 3105.18, okay? So, you understand in West Virginia and Ohio, we do the numbering a little differently. 31 is actually the book it would be in. Oddly enough, in Ohio, they do not have even numbered books. All of them are odd numbered. I don't know why we do that. I don't know why that happens. But it's 31 is the chapter, basically, and the Article 5, Section 18. So that's where those numbers come from. There's always some level of order of the madness on that. West Virginia, we do it a little differently, have dashes between the things, right? And we use even numbers. Okay, so we go to that statute. What do we find out in that statute?
But it's all very general.
It's pretty general, right? What does it talk about?
The conditions under which spousal support might be awarded. But it's something that the code makes individual determinations on based on specific circumstances. Is that right?
Okay, it means it tells us a little bit general. It may order, an award of may be allowed. Okay, everything's about may. Who gets to decide?
Right? Doesn't the court make the final determination?
In determining whether spousal support is appropriate and reasonable. It doesn't say that in determining that it is, it says in determining whether it's appropriate and reasonable. And in determining the nature, amount, and terms of payment, duration of spousal support, which is payable either in gross or in installments, the court shall consider all the following factors. So the court has broad discretion. You're not going to see that same language when we go to child support, by the way. There's not going to be whether you get you have to pay child support. It's going to be how much. It's going to be clear. Okay, so under the statute, the court shall consider these following factors. Does it say the court shall order it? No. So the court's going to go look at some things, and we know basically what they're going to look at. Basically, the first one, usually you do the things in priority. That's not, they'll tell you that they don't necessarily, but the income of the parties from all sources, including income from the property divided, that's called marital property, income from marital property that you might get distributed. Okay, the income. So in other words, we aren't really going to give you any spousal support probably if you can make your own money, right? If you already have. Then the second one they look at is relative earning ability. So again, we're looking at the same things. And then we look at age and your physical, mental, and emotional condition. Why do you think they look to that? It's relevant to the one about your relative earning ability, right? The younger you are, the more long time you have to potentially make more money, right? Support yourself. Retirement benefits, okay, how much might you receive? When might you receive it? How long is the marriage? Okay, that one's a pretty big factor. I mean, I already told you a little bit. If you don't think you've been about 10 years, it's not a real likely thing that the court will order. In any event, you're going to look through and they have all the different factors, but basically none of this stuff is binding on a court. Okay, so let's go back to our question. So could the court award spousal support? Do you think that it's an appropriate thing under the statute to award George spousal support in this case?
At least on a provisionary basis.
On some, it'll have a limited scope and time, right? Yeah, it looks like it. What is his income right now? We don't know that it's very much. The relative earning ability, we know he needs to go to school to increase his earning potential, right? His age, we don't know that. We don't really assume there's very much in the terms of benefits. We do know they have very little property, right? They have no children and no property to divide. So it's not like they own a home. They don't have a retirement account. They don't have any other assets. They don't have bank accounts with any money in them. They say the only real thing you could divide is the degree. Well, how in the world do you divide a degree? Right? He paid for it, right? He contributed, not for the whole thing, but he contributed to earning it. So just throwing that out, okay? So we look at it, we say, well, are they going to be custodian of a kid? No. What is the standard of living? We don't really know because she just started working, so back to work with her new degree. The assets, they don't really have much. He makes a contribution to her education, training, or earning ability, right? Now look at that language, kind of interesting. Education, training, or earning ability. Okay, education, that's an easy one to understand, right? Yep.
I have a problem. Does it say specifically in the facts that he paid for education?
No.
Because it's a possibility you can go here and
Sure.
have it paid for by scholarships and grants.
Sure. So it doesn't, no, and I don't think that that's necessarily important. It is, that would change it. If the reason she was able to get out without debt is because they were able to take his money and make it go and help pay for the debt education. But he certainly contributed to the education, right?
By holding down a job.
Because if she was able to graduate with no debt, and I mean, we can assume maybe there was some carryover money, things like that, but because he was working, he was helping pay half the bills, at least, okay, the food, things like that. So that's a contribution towards education. May not be dollar for dollar what was your tuition and books and things like that, but you see the point? The training, that's similar to education. So basically you can see the contribution if you go into that. The one that's a little bit broader that's still important in my view is the earning ability. How do you contribute to somebody's earning ability? You take care of the household while you travel for business all the time, right? It's how you do, right? One of the spouses has taken on roles that if it was not for that person, the other one wouldn't be able to do the things they do. That's an actually big piece of it. We also know that in certain professions, it may take 10 or 15 years to really start making the money. You have to put that effort in in the long-term shift. So anyway, that's all there. Tori's raised that I know you can't leave your spouse destitute, applied to wives, and is an old concept, but the wife in this scenario has the ability to provide for herself. Her soon-to-be ex doesn't. Isn't she legally obligated not to leave her spouse a ward of the state? That is true. Yeah, it still goes both ways, that you cannot leave your spouse destitute. You're right, it typically fell along gender lines in history, but that's not true today. We would still go with it being either spouse. You cannot leave either spouse destitute. Okay, so could a court award the spouse support? We think so, because contributed towards education in different ways, maybe not directly for tuition and direct costs, but other indirect costs. Okay, what type would it be? We kind of look at it being only really the two kinds. We don't really look at it being permanent support, right? You all think it's permanent support? Because you were married and you developed a standard of living while you were married, you're entitled to that support. Kind of what permanent's about. Realizing permanent usually still sunsets at some point. Okay, so we would think it's rehabilitative and reimbursement support. Okay, here's the $1,000 question maybe. How much would the court order?
Isn't it left up to their discretion? Can we assign a dollar amount?
It would be up to their discretion.
But can we assume from the total amount of their standing bills every month, the amount of support that they would get per month?
We could get to some number there probably, right?
Yeah. I think I got like, I think it's 1,000 or so.
So what would you do? You would take her income? I don't know. What would you do? What would you all do? How would you come up with a number to give to the court? Because it's true, the court gets to decide. It's up to the court. The court's going to decide the number, and what's it going to be? We don't know.
Well, we can't make it too much because Susan only earns $30,000 a year.
Okay.
She's gonna still have
100 a month.
How much?
2,500.
$2,500 a month gross,
I
right?
don't know what his income is.
if he hasn't,
We're assuming he has none.
right? Except this.
He's got Aflac.
We got Aflac.
So, okay, let's assume he can scrounge together some level of support, but we don't know it because you know how much he's going to present to the court? A goose egg amount, right? He's not able to work. He's going to, as long as he can prove it's a goose egg, he's not going to present, I can do odd jobs around and make $500 a month. He's not going to do that, right? Plus odd jobs are under the table and all this thing. Okay, so we're going to take her $30,000 a year, and what are we going to do? Make it per month, because we order spouse support in monthly terms. Okay, and we're going to look and see how much do her standard expenses take out of her monthly income. It's $2,500 a month gross. So what's that amount to net?
$1,400 a month on all of those that you have listed. What's the allowance of?
So it costs $1,400 a month.
These are $1,100.
If they both pay,
This here, well, your thing that I calculated.
Right.
I paid $150 a month of the sum amount. They come up to $1,400.
okay, so all their standard bills, not including the sum amount,
Well,
you put like $100 on it. $150 on some amount to get just to $1,100 or $1,400. So their standard bills every month cost them $1,400. She makes $2,500 gross. So should she pay him how much?
See, make that stipulation, shouldn't we just submit what we have, what we know that she has to the court so that they can make the.
I'm asking you because you're going to have to tell the court. The court wants you to answer that.
Yeah.
If you let the court do it, the court's not going to come up with one you're happy with. So let's assume you represent her. You're Susan, or you represent Susan.
Right.
How much do you think she thinks she should pay him? Let's assume she believes she should have to pay something. Okay, you remember, you can always alternatively plead and argue. So her first argument's going to be, I don't owe him anything, right? I shouldn't have to pay him. He can work. He's faking it. Whatever it is, right? He can work. He's just being a pain. Okay? That's the first argument. Second argument is, what? I paid for all the bills. I took care of the house while he worked. Yeah, all he did was work and complain, right? Third argument that she's going to make is, how much should she have to pay? If, court, you still don't believe me, how much? Alex asks, are the bills for each of the parties, or is that the total? I know out here $500 will only cover about half of our rent. So is that the total per party or all together? Actually, I put it per party because I noticed the income number was, has to be something that was complicated for income purposes. So she's asking, is that $500 together? No, it's actually, his house would cost him $1,400 and her house would cost her $1,400. Which is more than her monthly gross income, right? You're welcome. So I split it up. I didn't want to get it too complicated in math because it could be more in rent probably and things like that. But so how much should it be? $1,400. Both households cost them approximately. We're talking about how much for general living expenses, general things that you want to do. They're going to have to make some cuts. Okay, so cut the cable. Okay. Well, no, we're not talking about that. How do we determine? Let's assume we're not going to cut anything.
Well, then he's not going to be able to give him enough to cover everything.
Okay, so what is the amount she's going to argue? How would you figure it out?
It's not her responsibility to totally keep him.
No.
She's trying to cut him loose.
Well, I mean, it's disappointing to help him keep that way of life, but it's
Well,
not
it's to keep him from becoming a ward of the state.
it's not to continue and take care of him. I mean, she'd stay married to him if that was the case.
So it's to meet
Right.
his basic survival
I had
needs. Is that what it is?
$450 a month for approximately 1.5 years. I don't remember anything like that,
So
but
basically, her job at this point shouldn't be to take care of him completely. She may as well stay married at that point. That he gets to have his own house and take more than half of her income to enjoy his own house away from her, apparently. That doesn't seem right. I would take duct tape down the middle of the house for that, right? Yeah, chainsaw, you can have that house, that half. Okay, so Tori says, I think reasonably she could pay between $500, half the living expense, but a court could ask for a full $1,000. Okay, I think that there's some level of somewhere in the $500 range, maybe some reasonable amount. So let's think about her expenses then. She makes $2,500 a month in gross, realizing that any money she pays to George is deductible on her taxes. Okay, we can't even factor that in, honestly. Let's take that $2,500 and assume she pays approximately 15 to 20% tax, right? I can't do math in my head that fast. Let's go with she brings home net around $2,000 a month. Okay, she brings home $2,000 a month. Now she has to pay $500. That leaves her $1,500 of her own money, right? Is that fair?
Man,
Doesn't seem too fair, does it?
thank God for her. Single person, how much money you make it. Everything else. Well, we don't know.
Alex asked about disability for George. We think there might be some workers' comp. We're not going to worry about all his potential income sources because we don't know what they are. But that's a good question. We think there would be something. If he can't work for 5 years, he's got some additional income somewhere. Okay. Workers' comp, something else. Even then, those dollars still are delayed, can be delayed. Okay. Now Tori's put in a scenario. This isn't real life, and this wasn't in the homework. My always favorite start to a question. But workers' comp isn't just for the injured worker, it's to provide for the injured worker's family. Since they were married at the time of the injury, legally could probably have a right to the reimbursement he would get after his case was over. Oh, she could, I'm sorry. She could give a right to the reimbursement he would get. That's true. Probably some retroactive piece, he would get a bigger lump sum once it was paid in the future. I think it's right. Okay, so that, I think that gets, but that's true, yes. She might get some retroactive for it because she would get any that was marital property during the term of their marriage for their separation. We don't really know that there's very much of that time. Okay, but that's a good question. Yes, you would probably split that at some point. All right, we gotta move on past this one eventually. So how much do you think? 500 seems too much for her to pay, and 500 seems too little for him, doesn't it? Do you agree? This is a hard scenario. There's not really a lot of money here. They made it work before, but they're not, they were married then. Now they're not. Now you split two households. How do you do it? I don't know. I'm just pointing it out. This, the purpose of this whole situation is to show you how difficult this can be. Okay. So I told you that. How much is it? Court's just guesses. I mean, educated guess. It's not just like throw darts at the wall, figure out, oh, 250 sounds good. But how long should it be for? It seems like it ought to be maybe for 2 years. It does. There's all kinds of factors. So the point is, it's very difficult to make in such an order. Okay, but you got to support it with law somehow. Could the court award a division of the marital property? There's only the one thing, the degree. How do you do that? Okay. So one way, basically, she just reimbursed him to pay. She helps pay for his. Well, how do you figure that out? And remember, these people need to get done with this and move on. They need to be divorced and go do their own thing. What are any other ways you could split the marital property? How could you split the degree?
I don't think you should split the degree. Honestly, I think you should just.
I don't know how you do it.
Classes and-
Well, you can't really split the degree, but you have to make it dollars. You can split dollars.
Right. Equitably.
So how do you split the dollars?
Well, they're technically they already are if she's giving him alimony, right?
Sounds like reimbursement style support to me.
That's what I'm saying.
So is it really property distribution? Alex says she could pay him back the amount he paid toward her degree. Yeah, but then it would be hard to calculate potentially because some of it's going to be undollared contribution. Okay, so anyway, my point in all of this is saying this is a complicated subject matter. You might be able to split the marital property by saying for the next 5 years, there's some percentage of her salary he should receive. We can assume $30,000 is her first year and that she'd probably get raises and then he would continue to get that. But what percent would you make it? Is it 50%? No, that's unreasonable. That gets us back to our same dilemma. She would have no encouragement to continue working. The court orders a $1,500 spousal support payment. Why would she keep working? She'd be better off not, right? At that point, you're working just to pay your bills. Okay, we do it. Could court award alimony in gross? Yeah, I don't know how. They don't have any money to give, right? So the court could require it, but it seems kind of goofy to do it that way, right? There's no principle. There's no cash to distribute. So that's the answer there. Property distribution. Let's go through this really quick. This one's a little bit quicker. What's the statute that I was asking you to look at? I'm going to grade this, obviously, but we won't go into this great detail because I think this one is reasonably easy to determine the amounts.
48-7-104.
Okay? 104?
Yeah. least that's what I have.
That's the determination of worth. I think it's 103.
Okay,
The division without an agreement.
typo.
Sorry. So basically, you're going to go to the statute and you figure out what is marital property. The second statute, there's other ones that determine how much it's worth. Basically, you put in all the pot of money and you determine that everything that was marital and you split it evenly, right? You do as best you can to split it evenly. So that's what I asked you to do, and I put that together. And I think that's relatively simple. Are any of these items not marital property?
You mean marital property in the sense that they could be attributed to both parties?
Marital property is anything that would go be combined and then split evenly. So things that they acquired as a result of the marriage.
Yeah, I think there's a few things there that can't be considered marital property.
Okay, what? What's
Like
not?
the life insurance payment from death of Lily's father.
Okay, so her dad dies and she gets $50,000. Is that marital property?
No, that's
It's
only
not.
Nope.
hers. And then, yeah, the fine china.
Fine China, no.
And then each of their 401ks should be strictly to them.
Nope.
No?
Only the contribution that either exists prior to or subsequent to the marriage. Which, by the time those things are determined in court, there have been new contributions until the final time. So you have to determine what percentage, what amount of that 401k exists during the marriage. And that gets complicated. That's when we do the quadros and all that stuff to try to figure out the answer. But we would, in this case, because it's equitable and they're pretty even, we would make up for it and probably not get into a quadro because we'd say, well, the 97 goes to you, 82 goes to you, and then because we wouldn't want to make it messy. But it would still be marital property. We'd add it to the whole and try to equal it out. What about his ongoing car accident litigation?
If he's the only one withstanding, why would it apply to her? I mean, you know what I mean?
Why would she get, so we don't know how much, does she get half of it? It happens, let's assume that it happened while they were married before the date of separation.
Still, if he was the only one actually involved in it.
Of the two of them,
Does she have to pay his medical bills?
did she have to pay? Do you get a claim if you're a spouse in a car accident case?
Unless it's lawsuit.
Loss of consortium. So is a car accident litigation, that's a personal injury. Does she get to split if he gets anything out of it? Only her loss of consortium damages.
Right.
And you know what? Once you file for separation, you can't, once you're separated, you no longer can get consortium damages. So that automatically gets thrown out of a tort case. So we will look at it.
I have a question.
And if both of their names are on the car, would she get some, only the amount that existed to the amount of property damage, not his personal injury. She might be get it if her name was on the car. If it was payment for, that's what Tori was asking, if it has to do with the amount of, but no, his personal injury is his own. Okay?
I have a
Yes.
question. What about credit card debt? Because sometimes it's not in both names, it could be in one or the other.
Marital property exists without regard to the title.
Yeah,
Okay, so whatever the title is kind of irrelevant. But if it's credit card debt that exists prior to the marriage, and you pay marital funds to pay down the debt, then that was paying marital funds for a separate property, which means that you have to distribute that. You already distributed that during the course of the marriage. It'll come off of your line in an equalization. It becomes an asset. So let's say I have $50,000 in student loans that exist prior to my marriage. I spend marital property to get that down to zero. That $50,000 plus all the payments and interest that I paid on that becomes an asset on my side of the line. It's a simple accounting. Okay, so what you would do and why I told you to put it Marshall and Lily on there was to say you have to equal it out so that at the bottom it equals the same amount. So when you put the things together, sometimes you don't have any cash to make it up, and that's what we call an equalization payment. Okay, we'll have that in there too. A dollar amount of equalization that we put together. Okay? Any questions about that? All right, so now we should get into child custody. All right, that's a whole fun subject. This is where a lot of the battles come. And I just want to go and talk to you about a couple of issues. I have an outline, but it's really not, it's not that detailed because I don't think this area requires a lot of, the book explanations. You can read that and figure that out for yourself. But I want to talk to you about two concepts in law when it comes to child custody. There are something known as physical custody and there's something known as legal custody. Okay, they're two different things. Sometimes they merge, and parents, if you're married and you have kids together, you have both legal and physical custody of your child. Okay, so you have both things. So physical custody is what you think it is. I think physical means they are in your custody, your presence. You have control over them. You make their decisions. You are the one who makes sure they come home on time. All those things. Okay? That's physical custody. Legal custody is the right to make decisions about their upbringing. Okay? Decisions about their upbringing. The decision of whether or not they should have surgery. The decision about where they go to church. The decision about where they go to school. All those things are legal custody. So whether or not you have legal custody or physical custody isn't important to the legal custody question. Okay? They actually are two different things. So sometimes we know that as the parent that has the legal custody can have not all of the physical custody. You will sometimes have that a parent gets 100% of the legal custody and the other parent gets 50% of the physical custody. Okay? We call those visits usually. All right? Because one truly gets the biggest bulk of the decisions. All right, so I wanted to come to this page. This is the forms page on the West Virginia Supreme Court. And I wanted to point out to you the forms, and I think it gives you some pretty important information about how do you go about determining the worksheet or who gets parenting in West Virginia. Basically what we do is, how do we determine? So when parents are married and they have children, how do you determine who has legal and physical custody and what percentage? Equal, all right? So while you're married, you have the kids are yours together and you have 50-50, an undivided half of the whole, okay, to decide legal and physical custody. Do you discuss that much? Not really. You just come home and there they are, or somebody has made arrangements to pick them up. Who gives them the bath at night? Do you discuss that endlessly? No, you don't. Do you have a chart? Maybe. Depends on how you run your household, but you get the idea. Okay? When you're married, we don't think of these discussions. But when it comes to divorce, what happens? That relationship no longer exists. That old way of running the single household doesn't exist anymore. So how do we deal with the children?
Do you do it based on who gave the most care?
Yeah, basically. So what do we try to do? So let me go to another page here. Let's go to the West Virginia Code and look up the custody section. It's chapter 48, it's the divorce section. Pretty much this entire class comes out of that section, by the way. Chapter 48, and we're going to go and we're going to see a nice section that says allocation of custodial responsibility. So how do we know how much custody you get? Well, at this point, we have the breakdown of the old home. It's going to be different, right? So what do we want it to do? We want the relationship going forward to basically approximate for the kid what it was like when the parents were together. Is that really possible? Almost not. Almost not possible at all. I hate when I do that. you try to get it as close as you can. All right, so what do we know? The amount of time you spent having custody or taking care of the kid. Well, how do you figure that out? I don't know. But here's what you should look at. This is the general concept. Okay, this article, 48.9.101 of the West Virginia Code, sets forth the principles governing the allocation of custodial and decision-making responsibility for a minor child when the parents do not live together. Remember, that doesn't always come out of a divorce. It also can, you don't have to have this, you can have these orders without a marriage, okay, because you can have children without a marriage. Realize what this statute says is that the allocation of custodial, meaning physical custody, and decision-making responsibility, meaning legal custody. Okay, that's what those terms mean. The legislative finding declares that is the public policy of the state to assure what? What does the state want in these kinds of cases? The best interest of the child is the court's primary concern in allocating these things. Okay? We think that they should have frequent and continuing contact with parents who have shown the ability to act in the best interest of their children. And we believe we should educate parents on their rights and responsibilities and the effect their separation may have on children. What does that mean? We require them to go to parenting education. That's what that means. Okay? We want to encourage the mediation of disputes. Why do we do that? So we don't just yell at each other, right? We encourage mediation. There's actually court-mandated mediation in some cases for the children and determine who gets custody. And encourage parents to share in the rights and responsibility of rearing their own children. Okay. So what does it mean to be the best interest of the child? That's the next statute. The reason we're going through the statute here is basically this lays out the chapter in a different way. What are the best interests of the child? Stability, right? That's like one of the most important things for children is stability. Time moves very fast for kids. And if they don't know where they go home every day, it wreaks havoc. So that's what the first thing is about what is the best interest? Stability. Okay, we need to have parental planning and agreement. What's that related to? Stability. Continuity of the existing parent-child attachments. So we should encourage the visitation. Everybody being responsible and being around. Meaningful contact between the children. These things all sound great, right? I mean, it seems simple. It's really easy. We just go through our time and figure this out. Caretaking relationships by adults who love the child, know how to provide for the child's needs, and who place a high priority in doing so. Security, that's a big one too. Stability and security from physical and emotional harm. Basically, we get all that. And then under a new subsection B, we get a secondary objective of this article is to achieve fairness between the parents. Interesting, right? So let me tell you what most of these look like when they're contentious. Subsection B is the priority in the case. Really, that's it. Subsection B becomes the priority. Is that where the priority is supposed to be? No, right? The statute clearly says the primary objective is the best interest of the children. The secondary one, if we have to, we'll worry about the fairness of the parties. Really, we only mean fairness between the parents as it relates to two good, capable parents. Okay, what does that mean? We don't mean they all can do great things, and we mean that they meet a certain minimal level of appropriate parenting. Okay? So how do we know, where do we go to figure this out? Well, first of all, we want a parenting plan where we agree on it, okay? That may or may not happen. We might send you to services. I'm coming down here to get to the permanent parenting plan. You have to submit one, that's good for you. And how does the court determine the allocation of custodial responsibility? They look at 48.9.206, the allocation of custodial responsibility. All right, what this statute does is lay out the factors that the court will consider in determining how to decide the custody arrangement. Okay? More or less, how do we decide? We look at what we know as the percentage of caretaking functions. So that leads me back to this page. This is the form, the worksheet for individual proposed parenting plan. Okay, let me make sure I'm still there. And look what it says. For each responsibility, the blank should always add up to 100%. The daily physical needs and care. Who does it? Petitioner or respondent? Okay, who does the feeding, bedtime, and wake-up routines? Who cares for the child when it's sick and hurt? Bathing, grooming, personal hygiene, right? Who does that? Who does developmental needs? Who develops proper behavior? Who worries about education? Who develops the social skills, healthcare, moral religious matters, childcare matters? So you go through all those things and you determine what?
But it seems like all of that is subjective. If one party disagrees to what the other party says on that form, how are you going to resolve that issue?
Take testimony. The finder of fact will decide, right? The court. So you're going to present evidence. Isn't it pretty subjective? What is the percentage? Well, I do 4.5 baths a week. That's approximately 72%, right? I mean, seriously, how do you figure that out? Well, in my household, I'll give you an example. In my household, who feeds my kids breakfast? I do, every day. Who feeds them dinner? My wife does.
Right.
Who gives them their bath? We pretty much split them. We have two. So we split. It's easier that way. That way we don't have utter chaos in a flooded house.
Yes.
Okay? Who puts them to bed? We split that. So we're actually pretty close to 50-50, except for in the dispute, my wife would probably say, well, dinner takes more work because I just heat up something or put something in the toaster, right? Or I pour some cereal. That's it. That's pretty, is that really 50% of the at-home dinner or meal? No. You see what I'm saying? The point is, how do you determine those things, right? Sometimes in a lot of households, there's one overwhelmingly does that stuff at home. Okay? I always call it, they don't work outside the home. I always say that intentionally because they do work in the home. Okay? But the other one works outside the home. And how do you factor that into those decisions, these factors? You don't really. What if one person travels a lot for business? Are they doing much feeding, bedtime, wake-up routines, care when the child's sick? No, probably not. Are they helping them learn to walk and eat and toilet train? Maybe not. Proper behavior? Probably not, right? Does that mean they're any less of a good parent? No. So there's some things to be missed here, right? Okay, so I point that out. You want to go here to this form. This is the parenting plan. Now I'm going to give you this a little brief look at this. But what we do, and let me tell you this, what we do with those percentage of caretaking functions is we'll go through there and we'll go through that entire list that's in the statute, and the court will determine basically a percentage for each one, which is somewhat arbitrary, right? I mean, it's not like, well, I spend exactly 32 minutes a week doing that. I mean, it's going to be pretty hard to do. And they're going to come up with a thing and say, well, if one has more than 50%, we're going to say they get more time. But we're going to try to make that percentage something. Okay, let's say it's 75-25. Okay, so once we've done that, how do we decide what we do after that? How do we order that? You do 75% of the caretaking functions. You do 25%. How do I award you custody? Well, I'm going to give you the 75%, 70%, 75% of the overnights a year. I'm going to take 365 nights. I'm going to multiply that by 0.75, and I'm going to give you that many nights. The other one of you, I'm going to give you 25% of the overnights. How in the world do you do that? That closely approximates what it was like when you were at home, right?
Yeah.
When you were together, that closely approximates that, doesn't it? You get 25%. Now let's assume we took the first 75% of the days of the year, give you to you, and the other 25% give to the other. Does that make sense? No. What's another way? So let's go to 50-50. Let's assume everything's split down the middle and you get 50-50. How do you do that? Common way is 1 week on, 1 week off.
Ugh. I just don't see how that's very
That one's tough.
stable for the kids.
Okay. Another common one you'll get is 2 week night if you live in the same town. Depends. You can get really complicated when you go out of town and things like that. But if you live in the same town, more or less in the same school district, or at least where you can get to the same schools, you'll get like 2 nights a week and every other weekend. Okay. In my family, when I was growing up, my parents lived 2 hours away from each other. I spent most of my time with my mother, and I spent every other weekend with my dad. And then I got a couple weeks in the summer that different, and a lot of times like breaks and stuff. My parents got along really easily, so I don't know. It was whenever I wanted to go, I pretty much got to go. But the order was, I don't even know what it officially was, but more or less, I think it was every other weekend was what I got, because it was a 4-hour round trip, for the weekend. Does that look like 75-25? Does that look like 50-50? No, not necessarily, right? It gets complicated. That's the whole point of all this. So what you'll see in the order, and this is the reason I show you these forms, is that these are the ones we use for one thing. But you're going to determine these things. You can actually block out visits based on some factor in the statute. You can require supervised visits and transfers and all that. But you'll look at decision making, and you see all those factors that we just talked about. This would be a 50-50. This would be, if one or the other. I don't know. Petitioner gets to decide education. This one right here can be a pretty big factor. Religious matters. What church they go to. I've seen that be an issue. This one actually has a lot to do with vaccinations. You'll see that one in vaccination cases. Religious matter, who gets to decide if they can get vaccinations. But employment, all those things, you'll have to click. You got to make all these decisions. Okay, here's where when the children are not in school, you're saying Monday from this day to this time and all this stuff. It gets really complicated. Everybody's got their own unique way of how it works. When people have different work schedules and all kinds of things, it sometimes makes sense. When you were married, it was an easy one. It was like, well, I'm always home. I work Friday to Sunday, so I know what I'm going to do. And it was just a natural progression. But how do you do this custody in this one-size-fit-all form, right? Okay, so I say all that to tell you, you got to deal with all the holidays. And then usually there's this one thing down here, who is the legal custodian? Okay, that's important partly for tax purposes. It can also be important for then where they go to school, whether or not they're in district and things like that. How do you do your transfers? Who pays for the transportation between the places? Those things are all factors. You'd be amazed. There's a dispute on every one of these items. That's why they're on here, right? People have thought about them many times. How do you make changes? You always have to, try to arrange everything. Anyway, it's complicated. Settling disagreements, that's important. You should go to mediation. I don't know. Can you really go and pay a mediator every time you disagree? Probably not. And the other thing that's important to realize about parenting plans is that it is the base. You can deviate from it by agreement without ever having to go back to court, okay? It's just that this is the base for it. You can always give more time depending on whether it works, okay? All right, so basically what I'm telling you in this whole area is that custody of children relates very oddly to this concept of how much time did you spend caretaking? Because we want to basically as closely approximate that same thing going forward. Is that easy to do? No. Okay. Now, you'll also know that historically we had a maternal preference for custody, right? You all know that. Mom got custody of young kids. That's the way it went. By statute, we do not have that preference anymore. However, do you think it's really changed?
No.
Why?
Same reason marriage and disregard has not changed.
Okay, so there's still some gender
A lot of
roles
traditional-
things that
a
are
lot of
going there.
traditions Still in place, I think
You
it's
hear
important.
more men raising their children now.
Right, but I mean, I still think there's a lot of tradition that's still a long time.
Okay, so I think historically is why if it had always been that it was more or less even, we would have seen, we still see it continuing today with the statute change now. So there's that historical draw to it. Courts are inclined to go with what they did in the past. All right, it makes sense. Are there still, let's say, the majority, I don't even know if that's true, but the majority of parental situations where the mom does more of the caretaking functions? Probably yes. But we know more and more that that's not the given. It's not a given. But courts are still finding it. As you move through your life, you'll find that you'll hear a lot about dads who have been taken advantage of in the system. So why do you think that still happens, even so? So there's a historical basis. I think it comes down to the factors we look at. Daily physical care and needs and care. Just depends. We still have a gender pay gap, for instance. So it tends to be that men work outside the home more than women, or make more outside the home. Is that exactly, is there a fine line drawn there? No, but that tends to be how it works still. So that's one factor. But anyway, there's all those reasons. But I think a lot of these factors are ones that moms develop, for one thing. Not always, but for one thing they do. So I don't know. What do you do? There is some psychology that says that particularly boys under the age of 14 are better with their moms. There is some psychology that says that girls are better with their moms to a certain age too. There is some science behind that relates to that and says that it's better, especially until they hit a certain age. But just as things that you'll see. I don't know. It gets complicated for certain. Okay, so we covered then all this stuff about custody. I did mean to say that there is a quiz for next time. Like this next week, there's a quiz. That's our assignment for this week. Okay, and I forgot to tell you, but that covers the chapters 5, 6, and 7, which is, now I'll draw a blank on, I know the last chapter and this one, spouse support was one before that. 5, divorce grounds. That's a pretty simple statement. I also, as part of the test, I'm going to give you a case that you should read before you take the test. It's called it's the Brooke B case. And I'm going to give you that case, and I want you to read it, and I'm going to test you over it as part of the test. But it has to do with a very general concept known as, and it's really a newer area of law. It has to do with whether or not someone is a psychological parent. All right. We're going to revisit that area next time, and then we'll also revisit that area in another case that involves child support in a kind of related way. But what is a psychological parent? That is a non-biological parent, but who is as strong as a parent that the kid knows. Okay? So that's the case. I think you'll find the case interesting. And we'll go over it next time, but I'm going to ask you a couple questions about it. It won't kill you. It'll be relatively simple. Which tells me also that the key word is psychological parent for this week. And what is a psychological parent? It's someone who can be a step parent, it can be a grandparent, it can be a really just anybody that a child is attached to. There's some factors that go into that. And the case is interesting because it relates generally to the dad of this kid is dating the lady that's the alleged psychological parent in the case. And she fights for custody of the child. Okay. So it's an interesting case, I think. I think it's interesting. And it has a good result too, which makes it even better, right? Like usually you read these and then you're sad at the end because not the right thing seems to happen. But it depends on where you stand about when I think it's the right thing. But it's a good case in that sense. It seems to be a good result. So I'm going to provide that to you. You need to do that before you take the test because it's going to be on it in part. And we're going to cover the other areas that I've talked about. And psychological parent and custody of psychological parents is an important area in custody because what do you do if you are that and now you never were legally a parent to the child? Where do you go from here? Okay, that's the interesting part of the case. All right, so that's all I have for this time. Again, the key word is psychological parent. And we have a quiz next time over 5, 6, and 7 that will include that case. Okay? Thank you.